Hello and welcome to this edition of the Legal Podcast powered by IndiaLaw LLP. I am Aryaveer and today's episode examines the judgment of the Orissa High Court in Kankalata Dwibedi versus State of Odisha and Others, decided on 13 January 2026. While the dispute formally concerns entitlement to family pension, the judgment operates at a deeper normative level. It reasserts the primacy of statutory monogamy, clarifies the limits of welfare jurisprudence, and reinforces the idea that service benefits cannot be used to neutralize illegality under personal law. Family pension is often described as a measure of social security intended to prevent financial hardship after the death of a government employee. However, as this judgment demonstrates, pensionary benefits are not governed solely by considerations of dependency or compassion. They are legal entitlements flowing strictly from a relationship that the law recognizes as valid. The factual background is straightforward and largely undisputed. The appellant, Srimati Kankalata, sought family pension following the death of her husband, a government employee. During his lifetime, the employee had married the appellant while his first marriage was still subsisting. Although the first wife later predeceased him, the second marriage was admittedly contracted during the subsistence of the first. After the employee's death, the appellant applied for family pension under the Odisha Civil Services Pension Rules 1992. Her claim was rejected by the Controller of Accounts on the ground that she was not a legally wedded wife. This rejection was upheld by a single judge and subsequently challenged before a division bench in an intra-court appeal. From this factual setting, two core legal issues arose: whether a second wife whose marriage is void under the Hindu Marriage Act can claim family pension, and second, whether the expressions wife or wives in the pension rules can be interpreted to include a woman whose marriage has no legal validity. The appellant's submissions relied heavily on textual interpretation and equitable reasoning. It was argued that the use of the term wives in the pension rules indicates recognition of more than one spouse. It was further contended that since the first wife had already passed away, the appellant should be treated as a surviving widow. Reliance was placed on the Supreme Court's decision in Srimati Sri Ramabai, where pensionary rights were recognized based on long cohabitation and a presumption of marriage. The High Court rejected these arguments in unequivocal terms. Its analysis begins with a clear restatement of the law after the Hindu Marriage Act 1955. The court emphasized that monogamy is the absolute and unqualified norm among Hindus. A marriage contracted during the subsistence of a valid first marriage is void ab initio, and such a marriage is not merely invalid but also attracts penal consequences under Section 17 of the Hindu Marriage Act, read with Section 494 and 495 of the IPC. The High Court, in this intra-appeal, having perused the appeal papers, declined to indulge in this matter, though broadly agreeing with the reasoning of the single judge's impugned order. The court was particularly critical of attempts to justify the second marriage on grounds such as childlessness of the marriage. It observed that accepting such reasoning would undermine the very statutory configuration of marriage brought by the 1950 Act. Marriage, in its legal sense, is not contingent upon procreation and childlessness, and it cannot operate as an exception to monogamy. In support of this position, the bench relied on authoritative principles from Maine's Hindu law, reaffirming that consent of the first spouse does not validate a second marriage, and subsequent events cannot cure an inherently void relationship, and that the legitimacy granted to children of void marriages under Section 16 does not extend to the spouses themselves. When interpreting the pension rules, the court adopted a purposive approach rather than a literal one. It held that the family pension is payable to a widow and the status of a widowhood necessarily presupposes a valid marriage. The mere presence of the word wives in the rules does not authorize polygamy and does not override personal law and cannot be read in isolation from parliamentary enactments. In a striking observation, the court noted that the law is neither a slave to dictionaries nor a servant of grammar books. Interpretation must serve legislative policy, not defeat it. Pension rules framed under Article 309 cannot be construed in a manner that nullifies the Hindu Marriage Act or the criminal law on bigamy. The court also distinguished Srimati Sri Ramabai from the current case. The case involved prolonged cohabitation after the death of the first wife, allowing a presumption of marriage under the Evidence Act. In contrast, the present case involved an admitted act of bigamy. Granting pension here, the court held, would amount to placing a premium on illegality. Finally, the bench rejected the argument that the death of the first wife retrospectively validated the second marriage, applying the maxim of ex nihilo nihil fit, meaning out of nothing, nothing comes out, finding that what is void from the outset cannot acquire legality through subsequent events. This position has already been conclusively settled by the Supreme Court in the case of Rajkumari v. Krishna. The writ appeal was therefore dismissed. The court affirmed that the second marriage contracted during the subsistence of a first valid marriage cannot confirm the legal status of widow for pensionary purposes. The significance of this judgment lies in its clear reaffirmation that welfare-oriented service benefits cannot dilute or override substantive statutory law governing personal relationships. By denying family pension to a second wife from a void marriage, the Orissa High Court reinforced monogamy as a non-negotiable legal norm under the Hindu Marriage Act and ensures doctrinal consistency between service jurisprudence, personal law, and criminal law. The ruling decisively rejects equity-based or sympathy-driven claims that seek to legitimize illegal relationships through pensionary entitlements, thereby preventing the indirect encouragement of bigamy within public service. It also provides much-needed clarity to pension sanctioning authorities by confirming that the term widow under pension rules presupposes a legally valid marriage and that subordinate legislation framed under Article 309 cannot be interpreted in a manner that defeats parliamentary intent. In doing so, the judgment strengthens legal certainty, institutional discipline, and the integrity of statutory benefits. Thank you for tuning into the legal podcast powered by IndiaLaw LLP. Stay informed, stay compliant, and I'll see you in the next episode.